Hi, and welcome back. We're here for Module 4, Week 4. It's on interpretation and authority-based decision-making. Mainly this week we're focusing on statute-based law and therefore statutory interpretation. So we did some discussion about common law in prior sections. So now we're going to talk more about those statute-based laws, the ones that are written, the revised code in Ohio, the statute in any other state that you can check and look at what the legislature, U.S. Congress, the U.S. Code, or a state has passed. And these are also supplemented by administrative regulations, official commentary, interpretive rulings by the courts. The practice of statutory interpretation begins and ends with the written word. What is the marks on the actual page? And that actually in statutory interpretation is called what's the plain meaning. You're looking at the plain meaning of that. So there's 3 different sections on lecture notes this time when we're looking at part 1 of that. Starts again with common law, which is judge-made law, flexible law. It's creating precedent. What has a prior case said? What has a judge ruled? And how do we apply that to the facts of the case that we now have? So we've talked about that in some of the prior sections. And so we're starting the discussion this week about that as well. And then we want to focus more on statutory law. What's the concrete written law? Like I said, what's written down by the legislatures in the state, by the United States Congress. These are formal, concrete sets of rules that are passed through political processes. They usually are introduced as a bill. There's committees that may make changes in them, hold hearings, there's debates, and then they would pass a House or a Senate, then pass the other branch, and there might be a conference committee. And then coming out of that is the written law that comes out of that state or that United States Congress. When we're looking at statutory interpretation, it's the art of reading the law. And again, we're going to go with plain meaning if we can. But words can be vague, ambiguous, or just plain confusing. So there's plenty of times when statutory construction, in other words, trying to figure out what the law really means, has to be determined. So when this happens, there's different philosophical approaches taken by judges, such as originalism or strict construction. Originalism is when a judge looks at looking to interpret a law based on how the words would have been understood at the time they were written. In contrast, strict construction are advocates for narrow readings of the law, no stretching of the meaning, looking specifically what is contained within those specific words. I, in the past, helped write upper-level legislation statutory interpretation class for the Ohio State University College of Law and looked at things like in countries in Canada where the law is written in both English and French. What do you do if those words don't align? How do you determine what the meaning of that law is? So, in this country, we don't have that problem where it's 2 different languages that are involved, but still there's times where there's disagreements about what the statutes mean and what's contained within the meaning. So when we're thinking like a lawyer, lawyers have to not just look at the law, they have to consider how it's being applied in a situation, what the purpose of that law may be, and how it fits into the bigger legal picture. Lawyers need to know not just what the right outcome or the outcome they're seeking is, but who gets to make that call, because it also touches on institutional power. So we're going to talk about that a little bit in just a moment. And also considering that different courts, for instance, have different jurisdictions, federal courts versus state courts, and then also administrative agencies and others involved in this process. So looking then with the notes going to part 2, again, we're looking at not just understanding what the law says, but understanding the role of the interpreter. So in the process of statutory interpretation, as I already said, when you're looking at the first and foremost, can you determine the meaning from the plain meaning of the words within the words that are used themselves? That, of course, is plain meaning rule, the literal meaning of the words that are used in the statute. Legislative intent is another way that judges and others look at what the law is trying to say. What did the lawmakers intend? What was the intended purpose of that law? And that's when you look at legislative histories. I worked when I came out of Congress for the United States Congress doing legislative histories. We would take every bill that was introduced, and then we would go through the various versions, if they were amended, how they passed the House, and then how the bill was introduced in the Senate, amended versions again, and then if there was a conference committee report, and we would compile all of those, and so that they were readily available in the law library that I worked for, which was in the United States General Accounting Office. And there was a couple other branches of the U.S. Congress that did the same thing, so that all of those legislative histories, the bills, the acts, the amendments were all contained in one place, and those were readily available to the public. So legislative intent is sometimes easy to determine. Sometimes you can track that information. Sometimes it's harder to do. I don't know that states have departments that do just that it would be so easy to do, although you can clearly look at testimony that's presented at committees, and sometimes there are notes that are included in the legislative history. Another thing that's looked at is the broader purpose of the law. What was the fact pattern that they were looking at, the legislature was looking at? What were they trying to address when they wrote that specific law? And then there are canons of constructions. The ones that are noted in your notes are, because those are rules of thumb that are included, are things like the specific controls the general, and also the inclusion of one thing excludes another. So if it means this, that means that it may very well exclude this, and that we're looking at very specific. We're not making the law broader than it needs to be. Overall, the point here in this section is that the person who is interpreting the law is going to have a lot of influence on how the law is applied. So the next matter it turns to is why the interpreter themselves matters. And this is because judges have different philosophies. One of those is originalists, judges who believe in sticking with the original meaning of the law. Living constitutionalists believe that the law needs to be reviewed in light of modern values, even if it means departing from what the lawmakers originally intended the law to be. These are competing judicial philosophies. They are not ones that typically you would find a judge would have both those philosophies. They would be competing philosophies on how a judge is interpreting statutes and laws and cases. Additionally, in that is government agencies. The example used in your materials is agencies like the FAA, the Federal Aviation Administration. I personally worked for the Ohio EPA, where we were looking at taking laws and statutes and making regulations that were applicable to corporations, and then making determinations whether they were or were not in compliance. I did the same thing when I worked as a legislative analyst for Ducks Unlimited in Washington, D.C., where we were working on the Clean Water Act, the Farm Bill, and other laws that had to do with environmental impacts on wetland habitats. So we would work again with agencies like the EPA on a federal level on those kind of issues and the implications on what was important to our constituents. The material is also talking about juries are not asked to interpret laws, but they sometimes are in that role because they're asked to decide factual issues and whether or not the behavior that occurs falls within the scope of the law. So that then kind of overlaps a little bit into statutory interpretation when juries are making decisions on the applicability of laws to the fact pattern that is presented to them. So it's not just about how the law is interpreted, but who has the authority to make those interpretations stick. And the United States Supreme Court, that's the law of the land. If they settle a question, that's the end of the question. But if it's a small town court, a county court, or a state court, that might affect the people in that county. It might affect the people in that state, but it's not going to be applicable across the United States. So who's interpreting it is also going to impact who is affected by that interpretation. So this brings into question administrative powers and where those begin and end, how much power an agency has to not just create regulations to enforce statutes, but also their interpretation of law involved in that. So there's a whole power dynamic that's going on here, and a lawyer has to, within that power dynamic, make a decision where they're going to bring a case, whether it should be in a federal court or a more local court, state court, and which benefits their client in their specific situation, or even looking at precedent for those courts to see if there's a court that's going to be more likely to result in the outcome that lawyer is seeking. So the importance of statutory interpretation on real cases is presented in part 3 of your lecture notes. Tried to give you a wide variety of cases that you could look at. The first case study has to do with the Affordable Care Act, and there was competing courts on whether or not to look at the literal statute and the words that were used, or whether the overall purpose, what the court interpreted as the overall purpose, should be how that should be applied. The next one that I provided to you is a Second Amendment case that found a New York statute to be unconstitutional and that it violated the Second Amendment. And it referenced Heller, the Heller case, which had an originalist view of what was the historical founding of the Second Amendment. So one would be looking more at a overall purpose or purposivism. The other one would be an originalist. There's also a discussion of Chevron defense, which has to do with the Environmental Protection Agency and agencies interpreting rules and laws and then issuing regulations based upon that. And the last example it gives you about statutory interpretation is a Fourth Amendment case on whether or not the Fourth Amendment about search and seizure expands to include technological changes. So that's looking at modern day culture and expanding beyond what the legislature was looking at the time they wrote the law. So it kind of gives you a touch or a feel for all those different viewpoints and how they can affect what decisions are made and who's making the decision based on those philosophies. So the last page that talks about why the interpreter's perspective is key. Each of these show you that because they're showing you each of those different kind of things, and talks about judges' approach to interpretation, originalism that we see in the Second Amendment case, textualism, which was in some of the affordable health care decisions that eventually were overturned, purposivism, which is what is the example that then was what happened in the affordable health care, heavily influenced the outcome of the case. So you kind of get a taste across the board there. We talk about agency power, and there's an example there with the Chevron defense. And then evolving laws, society, and technology change. How does the court interpret that? And that's the last case example that you have. So look at those notes on the different things there, because there's a very good touch on how different philosophies impact how things are interpreted and then the outcome of the cases. We're also looking this week at chapter 4 of the book. This is the end of section 1 of the book, and it's on social choice connections. The author talks about every perversity in the book reflects on some important paradoxical result in the theory of collective decision making. So he references back about why the issue of consent isn't the end of all the discussions that we've talked about that throughout, and Zen's paradox. He turns then to the fact that our society is one in which everybody is entitled to at least a few things, in fact, regardless of how society feels about it. So he begins to talk about rights. And so we've been talking about that somehow win-win can lose to rights. So we're talking about that again, something that we think someone should be able to do even if someone else is supremely annoyed by him doing it. So the example that he's giving here is to talk, and we're looking at page 58 of the book at this point, is reading erotica. So the examples that are used in this analysis are, and this is Zen's analysis, is to imagine lewds and prudes. The prudes want to read erotica. The lewds don't want anyone to read it. And so they're offended by that outright. And so here we have these vastly disparate things. And basically end up with a situation where you can't have a win-win because the prudes don't want the lewds looking at this. The lewds don't want to be controlled by what the prudes are doing, and that a society that respects the individual rights cannot also respect win-win, because you're getting thrown right back into a paradox here again in this same cycle, that the rights and the win-win principle lands us in a cycle. This is Zen's paradoxical claim, and goes back to the problem of consent. Our incidences, like the consent isn't fixing this problem here. So then the book turns to why Zen's critics are wrong, starting at page 60, and talks about there's strong supporters of rights. They're generally also strong supporters of win-win. And here there's not a way to do that because we're caught in this paradox here. The suggestion that the conflict between the win-win and the rights can always be bridged by suitable bargains clearly won't work for the triage cycle or for its real life cousins. The win-win principle and the various rights claims stand in irreconcilable conflict. So we're again right back into this. And even if we say, okay, if the lewds are willing to give up their right, get more happiness from making the prudes read it, and the prudes are willing to read it so that the lewds don't read it, that still doesn't solve the problem because it's not enforceable. It goes to those other things that we've looked at before, that contractual rights constitute a much weaker kind of claim than a property right. So the paradox remains in place throughout this. So page 62 turns to further connections with the social choice theory and the anti-fairness theorem of Kaplow and Chevelle. So their argument talks about the fact that traditionally arguments about merits in legal rules use two kind of things. They usually address themselves to usefulness or uselessness of a law and its fairness or unfairness, which can also be defined as welfare or efficiency or practical consequences, versus the fairness, which is equity, rights, respect for rights, and seeking justice. So they then sought to formulate a legal rule that struck a balance between these. But Kaplow and Chevelle, in their book, Fairness versus Welfare, they then came to the conclusion that you have to ignore fairness and focus exclusively on usefulness. This is because they say if a legal rule can produce a state of affair that is better for literally every member of society, it should be adopted. And this causes them to claim that we have to not look at fairness. So it's called the anti-fairness theorem, looking at page 64. If our ranking system respects any of those fairness principles, their position is it will inevitably violate the win-win principle. The only way to avoid violating the win-win principle is to ignore fairness and concentrate on welfare instead. The example then that's provided to you in the book is that we could agree that all negligent drivers need to compensate their victims. But we can also, in their example, they're saying, okay, well, let's say this is true, and that in every citizen's lifetime, they're going to wind up being the victim of exactly one negligent causing accident. And we're also going to, for simplicity's sake, that the injury is always the same to every citizen. But not only are they all going to be the victim one time, they're all going to be the perpetrator or the negligent driver on exactly one occasion. And so then basically everyone imposes as much risk of injurious conduct on others as he is subjected to by themselves. So then the conclusion they come to is everyone would be better off if all injuries were simply allowed to lay where they fall. In other words, abolish the tort system. Because the win-win principle, everybody'd be better off if there is no compensation paid at all. This obviously does not sit well in our situation, and so the author, because our society does not believe that, turns in page 66 and talks about Kaplow and Chevelle are wrong in thinking that fairness should always obviously lose out to the win-win principle, that in real world, this is not what we're going to we're going to accept. That, in fact, we believe that win-win principles would have to lose out to fairness in every situation. And he points again to the triage cycle, and that it's more plausible to preserve priority rights at the expense of win-win for all the reasons we've seen in the prior in the prior chapters. So then the example the book looks at, again, looking at further paradoxes in the law on page 67, is Kaplow and Chevneau. They look at the fairness distinction that is made in the law between killing someone outright and letting him die, and that the law rigidly distinguishes between these two ways of causing harm, but says they also find that this distinction can be very easily circumvented through maneuvers that don't seem to have any moral significance. So the example they give is building a hospital. One worker is going to end up dying in that process. Is that a risk that society may be willing to take? But then the example they give is, well, what happens if you have a button and you can stop that person from dying, but then all the construction on the hospital that you've done is eliminated? Then are you causing the death if you don't push that button? So in other words, again, creates this paradoxical situation where you have a distinction in the law and they're proving to you that that distinction doesn't really hold true as you believe it does. So it concludes then on page 68 that it seems strange that factors that appear entirely morally arbitrary are in fact crucial to moral significance, this pushing of the button situation. But it's a larger issue. It turns out that it is impossible to design a plausible legal system that does not have this feature. And so the book's going to turn in part 2 to loopholes. And in fact, the title of part 2 is Why is the Law So Full of Loopholes? That we're trying to create these distinctions in the law, and yet there's ways around it. So that's it for this week. We are going to have the test. The test is going to be multiple choice, multiple answer, true, false. It's going to include some material from each of the readings and the lectures, so be sure that you're reviewing everything. It will be open note, open book. Thanks.